Hi, I'm Tom Spiggle with the Spiggle Law Firm, where we represent people who've been wrongfully fired or afraid that they might be. Today, I want to talk to you about your data privacy at work. It's all over the headlines now. There are hacks all the time into big government agencies and the huge corporations, all the way down to individual computer users. And so the question may be that a lot of people have is, what data privacy protections are there for your work data? So anything you might provide to your employer. And the short answer is that it's very spotty and very sparse. There are some laws that speak to data privacy. The Americans with Disabilities Act, Genetic Non-Disclosure Act also have some provisions in it that require employers to segregate information, for instance, related to disability, into a different file, and that provide some penalties for the improper disclosure of that information. But that's only as to those narrow forms of information that would be provided to an employer. There are other data privacy laws that apply to consumers. So, if you are purchasing something, you're giving your information over the web, there are laws, and there's a new one in Virginia now, there's one in California, one in New York, that do provide consumer protections for misuse of your data, including some significant penalties if a private company misuses your personal data. They don't, in most circumstances, apply to employers. So the question is, well, what do you do about it? Well, stay tuned is really the biggest answer. There are some possibilities that thought leaders in this area have come up with. The big one is called a data privacy, a data trust, which basically a trust is just like a trust for your financial information. It is an entity that holds something of value, and then there are trustees that regulate the use of it. So if you have a trust fund, then you have trustees that will regulate the expenditure of those funds. Similarly, a data trust would allow a third party, not the employer, to be the holder of that personal information. And then you would have trustees that would be charged with the proper use of that information. There are a couple benefits to this. One is, whereas you might be understandably reluctant to provide personal information to an employer, although it's hard to avoid these days, but you might be reluctant to do that. If you had a third party that was a regulated separate entity, then you might be able to might be more willing to provide that information knowing that it was going to be safe. For the employer, they can be assured that that they're not going to be on the hook in most cases. It's going to be the trust that would be on the hook for the use of this information. And so they would get that comfort. They could also be used, we're looking at from the employer's angle here, in instances where, let's say, social media accounts are obviously a big deal in employment law, and employment generally, and it bleeds in between work life and your private life. What if there's an allegation that you are distributing company confidential information on your social media, and the company wants access to be able to see if that's true? And let's say it's not. You're like, I'm not doing this. The company's like, well, we want to look. Well, do you really want to give your login information to your employer? Most people don't, but you might be willing to do it to a third-party trustee who could then look at the information and only provide the employer, your employer, anything that's relevant. So if there's no evidence that you've been distributing company information through your social media accounts, then nothing would be shared with your employer. So it would provide that level of protection for the employer to get access or to at least investigate that data, and to give some comfort to the employee knowing that only, not your whole social media account, but only those relevant pieces would be shared with your employer. But for right now, those are just kind of on the horizon. So wait and see. I'd say if you have a data privacy concern at your workplace, you can certainly consult your handbook. And if it does involve genetic information that your company has collected, for instance, through a company wellness program, or if it involves you submitting information to get an accommodations under the Americans with Disabilities Act, you do have protections for that kind of data. So again, circling back to the beginning, the answer is stay tuned. I think that we will see states and even the federal government step in at some point to help regulate data privacy. But for now, it's a bit of the Wild West. So consult your employee handbook. If you think that you are covered under these areas of the law that protect your privacy and that's been violated, then I suggest that you contact an attorney.